guys, it's Kathy. Hope your new year is going well. Um, all these videos are from like a couple days ago, except for one. So if you hear them say, Happy New Year, they're just behind the times. They're living in the past. But I got a Sov Cit case today that it maybe I don't know if you've already seen it before. It's probably gonna go everywhere because it's a Sov Cit. People love those. He's not that bad. He's crazy. He's not as crazy as some of them. The judge handles him like a pro. We got we got another one that I know you're not going to believe this, but I think the inmate might have lied. I don't know. It's hard to believe, but yeah, lying inmates. I got an attorney that is so mad, and I just am not on his side. I'm just not. And the first case I have is a great judge, like excellent, like phenomenal. You'll see. Let's start. Let's start with him.
Yes, Your Honor.
Second, tested positive for marijuana, September 23rd of 22. Do you understand that charge?
Yes, Your Honor.
What?
Those are the old ones, John. I'm sorry. Yeah,
Okay, that's right. Okay. So
I apologize.
Let's start that again.
Okay,
October
sorry.
31, in possession of drugs and drug paraphernalia. You understand that charge?
Yes, Your Honor.
Submitted a urine sample that day, tested positive for methamphetamine. You understand that charge?
Yes, Your Honor.
In October 31, arrested by Sheriff's Office for possession of a controlled substance and paraphernalia. You understand that charge?
Yes, Your Honor.
All right, Mr. Salem, what does he want to do?
Thank you, Your Honor. My client is prepared, Your Honor, to admit to the probation violation today. We have some things that we'd like to add regarding the court's decision on that. I'm not sure if it's appropriate to go into that now, or if you were just interested in what his plan was.
Yeah, just
overall.
Okay, so is that what you want to do? You want to?
Yes, Your Honor.
All right, what's your plea to those charges?
Guilty.
All right, I'll accept your guilty plea and find you guilty. Go ahead, Mr. Salem.
Thanks, Your Honor. As the court is aware, my client was on 5 years of community control sanctions, and very close to the end of that. He was scheduled to be finished just a few months prior to the events that caused these violations. He has admitted to me and owned up to his relapses and his issues with substances. He's been in jail for 51 days after waiving the probable cause hearing in this matter. During that time, he's behaved excellently at the jail. He's been assessed. The assessment has treatment recommendations. I've spoken personally to the assessor, and they are willing to accept him into treatment if he is released by the court. We are asking for the court to release him back into community control today with further order for treatment, outpatient treatment at Signature Health. He has a very good job that they are still holding for him. He's supporting his two sons, 10 and 12 years old.
10 and 14.
Sorry, 10 and 14 years old. 12 and 14, I apologize, that missed their father and would like him back in their life. I think he's learned a lot since being in jail on these violations. I think he's ready to make the turns that are necessary to get back into the community and stop using. I know that the assessment in this matter has some concerns over some of the discussions he had with the therapist who did the assessment. He's ready to address those today and address all the admissions that he wishes to make to the court. He has written a statement that he wants to read to the court regarding these matters. And like I said, I've met with him several times at the jail. He's owned up to me. He's willing to own up to the court and hopefully get into a more positive situation in his life. He has a lot going for him in the outside world, and he needs to get past these substance issues, and he's willing to try.
Thank you. What do you have to say?
Your Honor, I'd first like to say I hold myself 100% accountable for my mistakes.
No, you don't. Okay. You know why I say no, you don't?
Why?
Because that assessment from Signature Health is riddled with denials of use.
I apologize for the misunderstanding. What,
It's no misunderstanding, okay? It's no misunderstanding, okay? She reported in that assessment two things. You've been sober since January and you've been sober since March. Neither one of those are true. So why did you tell her that?
well, I told her that I was sober back then for a long time. It was only just a recent.
That's
couple
not what
months.
she said. These people do that for a living, okay?
Right.
And so when you tell her something, she records that. Okay?
I was scared.
Well, so what? You should be scared. Okay? So what you told her was not true, correct?
Correct.
Okay. So you don't seem to understand the significance of that, because you get assessed at that place and present it to me for the purpose of, in your mind, to arrange whatever treatment is necessary for you. Now, that report that she came up with is worthless. Your denial of use, if you're not using, then you don't need treatment. So why would I send you to treatment if that report says that you weren't using? Why would I do that? What's the point?
Because I want treatment.
For what? If you're not using, you don't need treatment.
Because I was using, and I'm sorry. I was trying to get off of it. I was trying to own up to it now. Trying to do everything I can right now. No, I said I was open to treatment anywhere direction I need to go.
You could say anything you want, okay? But when you go to get the assessment, presumably that dictates what type of treatment you should have. Now, what about these AA meetings that you're dummying up? What's that all about?
I was going to a couple here and there, but most of them weren't real.
Okay, why were you telling Miss Henley they were real?
Because I was scared to admit.
Okay, I don't care if you're scared. You should be scared, okay? Listen, you should be terrified. But you got to get over being scared, okay? Because you've been screwing around for 20 years with this crap, going back to November of '03, where you're trafficking in marijuana. Theft, possession, theft, receiving stolen property, receiving stolen property. That's all as a juvenile. Now, as an adult, possession, theft, disorderly, theft, burglary, drug abuse, receiving stolen property, drug abuse, aggravated possession of drugs. And then you get here with the aggravated trafficking of drugs. Then after that, those charges, obstructing official business. Then after those charges, aggravated possession of drugs in another county. So what is it you're scared of?
For a long time, I was scared that I had to admit that I actually had a problem. To be honest, Your Honor, I didn't want to admit that I had that big of a.
Well, I don't care if you wanted to admit it or not. Okay, I mean, you make a choice. Okay, you either address your problem or you ignore your problem. Now, there's a 20-year history of you ignoring your problem because you've been coming here and other places for 20 years.
Same here.
Because you ignored your problem. You've been ignoring your problem right up until real recently, when you're telling Miss Henley that those AA meetings were real, when she knew they were fake. I mean, you must think we are a bunch of morons, that we don't know that you're lying. She's been dealing with people at that probation department that lie to her multiple times a day. And you're the third guy today that's been lying to me standing right where you're standing. You're not a good liar.
No, I'm not.
Okay.
I'm really not.
So I have this worthless recommendation from Signature that says either inpatient or outpatient. There's a big difference between those two things because of the nonsense you were telling her. I mean, you might as well take that thing and throw it right out the window for what good it does.
I hope not to, Your Honor.
You hope not to what?
To have to throw it away.
Well, it's no good to me. What good is it when it's not accurate?
Everything I said to her was accurate besides my sobriety date, Your Honor.
Well, didn't you deny using to her also?
The most recent bit, I just simply didn't confess to her I was, yes. I denied.
What did he tell her, Cindy? You see, now I see, I know what's in there, okay, and
Yeah.
you're telling me one thing. Go ahead, Cindy, tell me what's in there.
The first actual sentence in the report, presented for assessment in jail, incarcerated related to new methamphetamine possession charge, denies use.
Okay, so that was within the last couple of months, right? Where you're denying use.
December 12th, Your Honor.
December 12th, okay.
Yes.
8 days ago, you're denying use to her, to the assessor.
I'm sorry. I'm nervous. I don't mean to imply something wrong.
Well, I'm not.
Sorry.
You were nervous when you were talking to her on December 12th?
Yes.
About what? About what?
Possibly getting a second chance to even do that. To be honest.
Well, don't tell me, don't use the phrase "to be honest," okay?
You're right.
Because that's when that's a surefire sign that you're lying. So we're here today, 8 days later, with you asking for treatment based on an assessment that somebody did that you were lying to 8 days ago. So again, why shouldn't I just put that in the shredder for what good it is? Because you just told me 120 seconds ago, the only thing you lied about was the sobriety date, okay? And it took like, what, 30 seconds to uncover that you were lying 8 days ago to her?
That's. I'm sorry, Your Honor. I'm willing to take a reassessment, have a current one for you. Everyone. Honestly, I just want to get better in my life.
Then why don't you do it? Well, why don't you do it?
I want to, right? I am.
Well, you're not. That's why you're standing here.
Can I please have an opportunity to?
To do what?
To make this right in my life, to get this over with.
Who's stopping you? Are you implying that I've stopped you from getting this right?
No. I plan to do whatever I need to do no matter what.
Which is what? What is it you need to do?
Get and stay sober.
Okay, so how are you going to do that?
I'm going to go dive right into the program.
What program?
12-step meetings. AA. Working on my character defects, my mind, my thinking. Obviously, my thinking was a right to think that I couldn't just own up to it. If I would have done this a long time ago, I might not be in this position anymore.
Where'd that meth come from?
From somebody I was given a ride to work.
Okay. Who gave you that meth?
This guy named John that I was given a ride to work.
Okay. John who?
I don't know his last name. I never did know his. He lives in Cuyahoga County. The only reason I was given a ride is because he totaled his car, and I was the only person that lived in Menor with him.
You were what?
I lived in Menor with him, and my
Okay, and he's from
supervisor.
Cuyahoga County.
Yes.
And you were giving him a ride to work where?
To Warrensville Heights, where I work. He moved in with his mother in Menor, and so that's the only reason I even got to know him at all.
How long have you been working with him?
As far as I know, I guess he's been there for the past year. I've only actually I don't work with him directly.
So he just gave you meth?
Yes.
So, is he in a habit of just giving away meth? Does he get it for free and he just gives it away out of the goodness of his heart?
It was for payment for a ride. to and from work.
See, this is what I mean. Okay? It's these little things, okay? When I ask you where you got it, you say a guy. Okay? And then I ask you his name, and you tell me his first name. Then I asked you if you paid for it, and you finally admit that it was for giving him a ride. These half-truths are not half-truths. They're lies. Okay? When I ask you a question, it's because I want an answer, not because I just feel like asking questions aimlessly. Where'd he get the meth?
I have no clue.
What was in the meth?
I have no clue.
No clue. You ever hear of xylazine? No? You heard of fentanyl, right?
Yeah.
Okay. You drug guys ought to kind of investigate what you're taking. So, since the beginning of this year, how many times have you used drugs?
I've never kept count. Quite a few times.
What drugs?
Methamphetamine.
What else?
I drank a couple times.
And what else?
That's it.
So where did you get the drugs the other times?
In the past,
Yeah.
from the last probation violation, then.
No. I mean, I asked you how many times you've used.
Oh, I picked it up from somebody who contacted me if I needed any.
Who?
His name was Brandon Bucky.
Huh?
Brandon Bucky,
Hey, how do you know Bucky?
old acquaintance. I used to run with him back when I was doing stupid things all the time.
Well, you've been doing stupid things. You continue to do stupid things all the time. So how do you know Bucky? I mean, do you have his phone number?
You got to hold me on Facebook.
Facebook. Facebook. Is there anything positive about Facebook?
I was just talking to my girlfriend back there about deactivating the account because it's just not really.
You ought to stop talking about it and doing it.
Yeah.
Why are you hanging around guys that you know are in the drug trade?
I guess when I'm using this, what you consume yourself with.
So when is the last time you were in any type of treatment?
Any type of treatment? Well, I was doing dual diagnostic counseling this whole time. I don't know if that counts as treatment for you. Other than that, the most recent time I was in treatment was aftercare. At the beginning of the time.
What
I was
dual
on probation.
diagnostic treatment?
It means I had mental issues and.
I know what it means, but
substance.
what were you doing?
Oh, I was trying to work on myself.
Where?
My thinking.
No,
my
where were you
trauma.
going?
Where was that?
Recovery resources. I'm sorry.
Where is that located?
It's located in Cleveland, on Pearl Road.
And you live in Menor?
Yes.
Why are you going to recovery resources?
At the time, I was living with my mother, and so I applied for the most closest place that there was there, and they were allowing me to continue doing treatment with them and counseling sessions over the phone when I moved in Menor. So I just kept it going with them.
And how often were you going?
Every week to every other week. Sometimes we'd do a session every other week.
When's the last time you went?
2 weeks before coming to jail.
It wasn't doing any good for you.
It was.
So why were you using meth?
I started and it was hard to stop.
Well, I assume it is.
Oh,
So how is the future going to be any different than the past if it's hard to stop?
because I'd be actively in treatment.
You were actively in treatment.
I mean,
You were doing individual counseling. You were as active as you could get.
I would like to get into IOP or inpatient.
Why didn't you do that before?
I was scared to admit that I really, truly had that intense of a problem still. I was, if I did something like that...
You've been in and out of jail all year on this case. And you didn't want to admit you had a problem? What, was just bad luck or what?
I didn't want to admit that I had relapsed after I got out of jail. I was scared because I was a little ashamed that I allowed myself to get to that point.
Oh,
again.
get over yourself, will you? Get over yourself.
You're right.
What else you want to tell me?
Well, I prepared what I wanted to say because it's hard for me to think straight when I'm nervous, so I wrote this at it. I made a mistake, but that's the easy part, admitting I did. The hard part is truly owning my mistake. By that I mean addressing my character defects I thought I'd overcome to prevent this kind of situation happening again. That's quite difficult to do while incarcerated, but not impossible. I plan to do whatever possible no matter what. I've had a couple setbacks this year. I know I have no intention to ignore it because if I do, I won't grow from it. But it's also important for me to acknowledge how far I've come and what huge accomplishments I have achieved in the past 5 years, almost 5 years I've been on probation in this new journey, or should I say direction in my life. I emphasize the word direction because before all this, I didn't really have one. So that's huge for me. I aspire to be a man of integrity, the kind man my kids can look up to and be proud to do so. I got back into my kids' lives over the past few years and was able to reconcile and redevelop a great relationship with them. They're entering the teenage years now. That alone was my biggest accomplishment. My father walked out of my life when I was 10 and left me to figure out how to be a man of my own. So not being a deadbeat is my proudest accomplishment by far. I've gotten my license back, managed to maintain a job at one place for more than 2 years straight. I did stay sober and productive throughout the toughest part of the pandemic, which is a big accomplishment, I feel. Held myself accountable throughout pretty much the whole time on probation till the most recent year. Moved out of my mom's house finally, got reliable transportation. Aside from the most recent setback, I stayed out of trouble. I paid off probation costs and almost all of my fines. These are just a few of the many accomplishments I achieved over the past few years. And I don't plan to stop growing no matter what. I just really hope I don't have to start from scratch again.
Well, aren't you starting from scratch because you're right back where you were 20 years ago?
No, because I've grown a lot. I just haven't. I'm still an addict, Your Honor.
No kidding.
I'm not a bad person.
I didn't say you were a bad person. Did I ever say that you were a bad person?
No,
You're a guy that just won't help yourself. You won't help yourself.
I love my pride.
You want me to help you. Why do you want me to help you?
Sometimes I need that help, that extra shove.
Then why don't you get it? Okay. I mean, you've proven to me that you don't listen to me, so I have no effect on you. You don't listen to Cindy, she has no effect on you. You don't listen to anybody. I mean, you think I got some kind of magic wand?
No.
I have nothing to do with whether you get over your addiction, contain your addiction, live a productive life or not. I have no influence on that. Where do your kids live?
In Burton with their mother.
Okay. Where do they go to school?
At Berkshire.
What grades are they in?
9th and 8th.
Okay. How often do you see them?
Every weekend, at a minimum every other weekend. Sometimes I see them throughout the week. Working second shift, I haven't been able to make it to all their games during the week, but every weekend, at the very least, I always go to my oldest son's football game. I mean, I'm active, involved in their life in every which way I can.
Do you use drugs with them?
Absolutely not.
Why not?
I just...
Why not? good enough for you.
It's not something I want to influence my kids with.
Then why don't you stop doing it yourself? That's the dumbest goddamn thing I've ever heard.
I know.
You don't want to influence them, but you're doing it. So do as I say, not as I do. Is that what you're telling them? That's exactly what you're telling them. Do they know where you are?
Yes, they do.
Okay. Do they know why you're here?
Yes.
What did you tell them about why you're here?
I said I relapsed. I didn't do the right thing. I don't hide my mistakes from them because I want them to understand that you can't be sheltered from life. You know, I make mistakes, and these are possibilities that all more reasons to stay away from drugs, stay away from doing things, and I try to support them as much as possible doing the right thing.
So you give them advice that you don't follow?
I support them. I'm there.
You give them advice that you don't follow. You're telling them not to do drugs because bad things happen, but you use drugs and bad things happen. So you're giving them advice that you're not following.
Yes.
Why is that?
I guess I want to be someone to look up to at times when they don't know what's going on.
Where do you work?
At Henkel.
What is it?
It's a manufacturing plant.
What do you do?
I'm a chemical mixer.
What do they make?
Mostly silicone products. Our biggest product is Loctite.
What are your hours of work?
3 o'clock to 11:30 p.m.
What days?
Monday through Friday, every other weekend on Saturdays.
Thanks, Heather.
How long have you been sitting in jail?
51 days.
What have you been doing?
I've been working out to try to keep stay focused, doing the right thing. I've been attending the only AA meeting that they offered us. I've tried to stay positive and productive with whatever I possibly can, you know. For the most part, I keep to myself because I don't want to engage with the stupidity that goes on, you know. I'm just trying to stay focused in the right direction with the best I have available to me.
Anything else you want to say?
I would really love to be able to see my family this year, Your Honor, for the holidays, the remaining holidays, and I really love an opportunity to be able to correct my wrongs. And I'm also sorry to Cindy for lying to me.
Have a seat. When did you get your license?
I got my license back 4 years ago because I had to renew it in January, actually.
Keep you on community control. You're going to serve 51 days of credit for 51. You're going to do an IOP at Signature Health and follow their recommendations. Maintain full employment. Utilize only one doctor, one dentist, and one pharmacy for any prescription medication. Any medication is to be taken only as prescribed. Sign releases. Have no drugs or alcohol, and you'll be screened. And pay the costs and supervision fees. Does all that sound familiar?
Yes, Your Honor.
Why is it familiar?
Because this is something I agreed to already.
Something you were ordered to do already.
Yes.
We're not making agreements here.
Right.
I'm making orders that you usually don't follow. So they're not agreements. Now, you got this other charge floating out there that automatically comes to me. Did you realize that?
Yes.
Okay. And any new charge you get in the next decade automatically comes to me. Did you know that?
I did not know that.
You know that now. Have you enjoyed this past 45 minutes?
It's been nerve-wracking. So
We've
no.
enjoyed it.
Okay. Now, I don't have, as I said, the slightest ability to make you comply with what I just ordered you to do. And you know what? If you don't want to do it, that's fine. No skin off my nose, okay? I'll just send you to prison. And then you'll come out and you'll reoffend. Or you'll do this stuff and maybe you'll reoffend. Or you'll do this stuff and maybe you'll get your shit together and you won't reoffend.
That's my goal.
That's your hope?
My goal.
Your goal. It's great to have goals. It takes work to accomplish your goals. So you decide if you want to work to accomplish your goals or if you want to keep coming and seeing me. Do you understand everything?
Yes, Your Honor.
Do you have any questions about anything?
No, Your Honor.
All right, so if you violate, and I find you violated, then I'm done with you. There's nothing else to do. We can't keep having the same conversation, okay? If you don't succeed, it's because you don't want to succeed, for nothing else, okay? And I don't want to hear, if you come back, that you're an addict and you're relapsed, okay? Okay? You're an addict, and it's your responsibility not to relapse.
Yes.
So if you come back again, I'm going to assume you don't want to do it, and I'll send you to prison.
Thank you, Your Honor.
For 54 months.
That's fair.
And when you get out, you might be on post-release control up to 2 years. With the parole authority, if you violate their conditions, they can send you back again. For up to 9 months for each violation, up to 1/2 of what I sentenced you to. If it's a new felony, and you subject yourself to an additional consecutive prison sentence for the violation of 12 months or the time you have left under post-release control, whichever is more. Ms. Henley, do you have anything else?
Your Honor, would you like Mr. Zovas to continue to attend AA meetings?
I don't care, because he's just going to dummy up the things anyway. If you think AA is going to help you, then you'll go to AA, okay?
True.
Now, you may be smarter than everybody in this room and know the secret to beating this thing. And you may convince yourself that you don't need anybody's help. Now, if I were you, I'd probably get involved in that. I'd probably get a sponsor, so next time you're running into the knucklehead that needs a ride, and you open yourself up to this temptation of relapse, and maybe you'll call your sponsor and talk to your sponsor. But look, you figure it out, okay? What I tell you doesn't do any good. You do whatever you want anyway. So you figure out if you want to go to AA meetings. Anything else, Mr. Salem?
No, Your Honor.
Okay, listen. You're now how old?
I'm 32 years old.
Okay, 32 years old. So since you were 12, you've been screwing around, okay? Time to grow up.
Okay.
Thank you, Your Honor.
Deputy, report to probation upon release, okay?
Okay.
He knows where to go. Thanks, Cindy.
Thank you.
You want to keep that?
Yeah.
Yeah, hang on a minute. All right.
Where is part one?
All right, they're taking you back over.
Thank you for the paperwork. Okay. Thanks. Hey, so if I'm being released on this, what does that do with the?
Well, that'll go to grand
Charges.
jury, and a new charge will come, and you'll get a bond on it. I'll talk to you about that.
Okay.
Next couple of weeks.
I'm not being held on that?
No, you're not being held on that. No, it's not charged yet.
Okay.
Yeah.
I wish more judges would just talk like that. Yep, Heather, you're right. Middleton does. This judge is harsh, though. He's just way harsh. This guy, every single time he opened his mouth, the judge throat punched him. And he stood there and he took it. The only two times I think this guy actually told the truth was, I'm still an addict, Your Honor. That was from the heart. That was true. That was the only true thing he said up until that point. And then the next point was when he said, I want to spend the holidays with my family. That was true. You could hear it. You could tell the way he was talking that it was true. He's a bad liar. Oh, yeah. All right, let's get one where the attorney is just mad. But I don't agree with him.
Morning, Alice.
Good morning. Okay. Attorney Plumai, I don't believe we have anything else that you might be required for. So if you wanted to sign out, that would be fine.
Okay, great. Thank you.
Okay, you are welcome. Okay, now calling case number 23S00824. This is the state of Michigan versus Derek Vorbach. May I have appearances for the record, please?
Attorney Ellis Friedman for the defendant, Derek Warbeck. That's Derek there in front of you.
Okay, thank you. Mr. Vorbach, can you state your name, please?
Derek C. Vorbeck.
Okay, thank you. This is the date and time scheduled for an arraignment. A complaint for a misdemeanor has been filed against you. It charges that on or about November 26, 2023, at the location of 10343 East Bemis Road, that you did commit the offense of larceny by stealing a cell phone that belonged to Cynthia Barnes. The value of the property stolen was $200 or more, but less than $1,000. This is contrary to MCL 750.356. This is otherwise known as larceny. This is a misdemeanor carrying a maximum penalty of up to 1 year in jail, $2,000 or 3 times the value of the property stolen, whichever is greater, plus court costs, or both. Do you understand the charge against you?
Yes.
And do you understand the penalty?
Yes.
Okay. Then at this time, Mr. Friedman?
Well, first of all, I'd like to state that I'm not going to try the case at an arraignment, but this is probably in 41 years of practice, the most ludicrous charge I've ever seen in my life. And I've been practicing criminal law for 41 years. He's literally charged with stealing his own phone. And it's mind-numbingly ignorant of the prosecutor's office to charge him with this offense. Secondly, the phone in question, which he pays for, was returned to Cynthia Barnes the next day after he downloaded some incriminating text messages from it. This is ridiculous, and I'm staggered by the incompetence of somebody who would file these charges, who would authorize these charges, and I'm going to deal with it accordingly. Mr. Vorbeck's lived in this community for basically his entire life. He has no criminal record that I'm aware of. I've represented him for, I don't know, Derek, 30 years?
30 years now, brother.
Yeah, and this is staggering. So I would ask that he be released on his personal recognizance. He's not going anywhere. He hasn't gone anywhere in 40 years. And I'm dealing with Ms. Barnes' attorney on the civil matter. They have some property that needs to be divided up as they're splitting. But this is just to say it's ridiculous is almost complimentary. So I'm sorry for the diatribe, but that's just the reality of it.
Okay. Thank you. Noted.
She didn't care one bit what he said.
I haven't figured out yet how you steal your own phone. Anyway, we'll get to that. We'll cross that bridge when we get to it.
Is the Bemis Road address your home address?
Yes, ma'am.
And does Ms. Barnes currently reside there?
No, she does not.
She did.
She did, but she stays at her son's house now.
Okay. And Attorney Friedman, you can confirm this?
Yeah, it's not an issue. They no longer reside together. They did until he found the phone with the incriminating messages on it.
Okay. So based on the information the court has now and the statements from your attorney, Mr. Vorbeck, the court will set a PR bond with the following conditions. There's to be no use or possession of alcohol, marijuana, or illegal drugs. You are not to leave the state of Michigan without the court's permission. You are not to commit any other crimes. There's to be no assaultive behavior against anyone, and specifically Ms. Barnes. You are not to have contact with her in the meantime. If she calls you, don't answer. Do not.
I haven't been answering.
Okay. You are not to possess any firearms, ammunition, or other dangerous weapons. If you do
None
have
in
any,
the house.
okay. If you were to have any, they would need to be surrendered. To clarify, when I say no assaultive behavior, no making threats of any sort either. When I say no contact, I mean nothing in person, over the phone, over text message, email, through third parties, or anything.
That's fine with me, ma'am. It has been going that way since Christmas night.
Okay, thank you. So at this time, your next court date will be a pretrial conference on January 22nd, 2024 at 9 a.m. over Zoom. That will be in front of the judge. Just one moment.
That's going to be Zoom, magistrate?
Yes, that will be Zoom. Okay. Okay. So to clarify just a little bit further, you are not to go to wherever she is staying either.
I understand that. I have not been there.
Okay, thank you. So then at this point, as I said, the court is setting a PR bond. You've got your next court date is January 22nd at 9 a.m. Attorney Friedman, if there's nothing further, then the parties are free to leave.
There's nothing further today, but there's going to be a lot further. Thank you.
Thank you.
Inappropriate, attorney, inappropriate. Here's what I think. I think that they were in a relationship. He was paying for the phone, but that's his girlfriend. And then they got into a fight, whatever, she moved out, and then he stole her phone that he's paying the bill on. He stole her phone. He downloaded, I don't know, her text with another man or whatever it was that he downloaded, um, and then gave the phone back. But she had reported the phone stolen, and he got charged with it. And he's saying, well, it's my phone. I pay for it. So it's not a crime. And I gave it back. Well, if you gave it back, then it's not yours. It's not your phone. You can't just, give someone a phone and then take it to download incriminating evidence, which he did, and then give it back. No, that's against the law. So I think this attorney is just wrong. And I think his posture and the way he's presenting everything is wrong too. I think it's very unprofessional. Like he's thinking this major conspiracy is going on and giving this guy hope that it's gonna turn out badly for him. I think, but we'll see. Well, while we're mad, let's stick with mad.
Dilka. And we're here. Ms. Langley's here. So Mr. Dilka, you're Christopher A. Dilka?
Correct.
And what's your date of birth, sir?
2581.
Okay. And the last address we have, is that good for mailing?
Yeah.
Okay. Let me turn to Ms. Langley here.
Thank you, Your Honor. I have had an opportunity to talk to him about the one charge that I think he's still pending arraignment on. In any case, he does understand his rights, and on the newer charge, entering a plea of not guilty, asking for counsel to be appointed. I think Pacific Point already represents him on the other charge.
Yep, I will appoint Pacific Point Defense, Mr. Dilka, for both of these. You pled guilty December 14th to theft. That's a probation issue now, potentially. And this arraignment is an allegation of December 27th. That's theft and obstructing law enforcement. So you'll have an attorney to represent you on both. And I'll enter a plea of not guilty to that December 27th allegation of theft and obstructing. And I need a judgment sentence that reflects both charges on that new one. Yeah. And then I'm going to hear from the attorneys. Mr. Sharp, on behalf of the city.
Thank you, Your Honor. So we have that backup case that he's on probation for. City's moving to revoke probation based on this new law violation allegation. Point out that that case is pretty recent. December 7th, he was arraigned on that. At that hearing, the city pointed out that Mr. Dilka has extensive criminal history, rich warrant history therein. 3 active warrants, 2 different jurisdictions, including Superior Court in this county. The court did order bail at that hearing. City would submit that circumstances are all the same, with the exception of now we have another allegation of theft, which is in violation of probation. So if anything, the situation is exacerbated in terms of likelihood to fly. So city's asking for $1,000 bail on these, on each. Law-abiding behavior, no contact with target on the newest case.
If your client's seen Thursday County Superior Court yet, well, probably not. He's in Nisqually, so there's Olympia. Okay. So, Ms. Langley.
Your Honor, he's not, I don't know what's going to happen with the other cases. I do know that he's not in a very good position to post bond. Ask the court to consider releasing him on these charges or just nominal bail, please. Thank you.
Okay, well, Mr. Dilka, I see that you don't respond to Superior Court nor to Olympia Muni Court. You're not a good risk to release and you continue to offend. So,
what do you mean?
Have you, yeah, well.
So on Superior matters, I've reported everything that I've done. It doesn't matter. Just do whatever you're going to do anyway for it. You guys are in process and sequences and the structure anyway, because you're stating comments and elements that aren't even a factor. I've reported and I've conducted everything that I've done for Superior matters and every other matter responsible. I'm walking down the street and then I brought forth before 2 officers to be detained for whatever reason. And without even, you know what I'm saying? So I've done a lot of things. You look at my record, and you guys keep saying all these negative elements towards this condition. So just do whatever you're gonna do, and then just process it. It's ridiculous, man, that you guys structured this kind of condition. You really don't even have jurisdiction in my life to conduct and perform such natures anyway. So anyway, just go ahead. I'm done.
No jurisdiction.
All right. See you, Mr. Dilka. You decided to leave the hearing. I'm going to issue a 1,000 total, 500 cash for bond on each matter. Set these for hearing January 9th, 10 o'clock for a probation hearing and a pretrial hearing with Pacific Point Defense. Of course, not to contact cold stores and not to violate the law. Was there anywhere else in particular?
Target on the new one, Your Honor.
Target. It's gone. Left already. I don't know what it is. Did I say 10 a.m.?
Yeah. When he got up, she's like, okay, bye. You guys are looking at my record and just putting everything down negative. Well, yeah, your record is negative. It's not good. It's bad, dude. Bad. All right, we're going to go to the next one where I think that maybe he lied to his defender. I think.
This is Mr. Cervantes. All right, let me catch up to him up here real quickly. Actually, yeah, so let me check something real quick. Let me explain my notation on here. Some concerns. Ms. Jacinto, he is a public defender client, okay? I checked on him. He's been appointed because he might need some of your services just from reading the case.
Yes, I know.
All right. Sir, you're here this morning because you're scheduled for a bond reduction hearing. You have 2 misdemeanor charges and 1 felony charge. Your felony charge is possession of controlled substance, penalty group 1, less than a gram with a $1,500 bond. You also have a charge of criminal mischief, that is damaging other people's property with a bond of $1,500. And you also have a misdemeanor charge of assault with a $1,000 bond. This morning, your permanent attorney is the public defender's office. This morning, Ms. Jacinto from that office is representing you. She's going to present evidence on your behalf to try and convince me to lower your bond. Then I'm going to hear from the prosecutor, then I'll make my decision. Go ahead, Ms. Jacinto.
Judge, just so you know, he didn't know a lot of information. So what I'm going to tell you is what he told me.
Okay.
Mr. Cervantes appears to be 42 years old. He's a U.S. citizen. He says that he'll live at an address at Titanic, but he doesn't know the number of the house. He does have a friend's phone number. He was unaware of if he graduated from high school or what his level of education was. He was unaware of his relationship status. He was unaware if he had any children or not. He was unsure if he had any ties to El Paso. He told us that he worked at Skyline Vet Hospital. He told me that he had $107 when he came into the jail, and now he only has $7 to post towards his bond. He doesn't know where the $100 went. He says he doesn't have any mental health issues and that he's not receiving any benefits, Judge. As far as the assault is concerned, Judge, the complaint affidavit indicated that the complaining witness on that case did not feel any pain. we'd ask that you reduce and or PR his bonds.
Hold on a second. Mr. Cook, just go over the criminal history.
Yes, sir. So 2014 criminal mischief, a 2014 theft, a 2015 trespass, 2015 assault, the 2020 burglary of a building, 2023 burglary of vehicle, 2023 burglary of building, and a 2023 criminal mischief.
He's only going over negative. That's not fair.
All right, Mr. Cinto, on this one, I'm gonna pass it up on, gonna reset it for, if you guys come up with a good safety plan, the court might consider a reduction, okay? I'm gonna reset it for 1-5 at that would be on, see, 1, 2. I'm gonna set it, do you want 4 or 5, Thursday or Friday?
5.
I'm gonna reset it for 1-5 at 1:30. If you guys come up with a good safety plan, then the court might consider doing a reduction, okay?
Okay.
I think there are other issues that are not too up, they're not coming out here, so get your social workers working and then we'll take another look.
Okay, thank you, Judge.
So what I did for me, so that I don't ever get in this situation, is every time I had a kid, I like wrote that down. That way I don't forget that I have like kids. And if I'm single or in a relationship, I post that on Facebook. That way I don't forget if I'm in a relationship. That's where this guy made his mistakes. That's what happened. Maybe I should call the jail and see if I can talk to him and give him some coaching advice on writing things down on paper with pencils. Pencils aren't only good for cassette tapes. They're good for writing things down. All right, guys. We're going to... Oh, I didn't write down their birth dates, Cloud. Sugar. Well, maybe one of them will know and they can help me write it down. All right, we're going to the Sov Cit. Here we go.
The Third Circuit Court for the County of Sheboygan. We are providing public access both to the courtroom and also online. And we'll call the case of People of the State of Michigan versus Trevor McLeod. It's file 23-6748FH. Please.
All right, reserved.
Mr. McLeod, we were here last time and tried to conduct the arraignment, and you ended up being held in contempt, and so we're continuing the arraignment to today's date. So let's try again. All right, so Mr. McLeod, I've got to obey the dictates of the Michigan Supreme Court, and they make me go through certain things. Sure. You're here without a lawyer. So I need to obey the Supreme Court and establish certain things so that I can make sure that you can represent yourself. So you've got the right to represent yourself or to have an attorney represent you. You can't do both at the same time. So I need to establish which one you're choosing. So to do that, I have to first advise you of the maximum charges that you face. Count 1 is a charge of resisting obstructing a conservation officer with a habitual second notice. It's a felony punishable by up to 3 years and or $1,000 fine. Count 2 is operating a motorboat while intoxicated. That's a misdemeanor, punishable by up to 93 days and or $100 to $500 fine and or 45 days of community service, suspending the privilege to operate a vessel, cost of prosecution, or emergency response. Mr. McLeod, do you understand the maximum possible sentences for those charges?
Can I say something for the record?
No. I'm asking you a question. Do you understand the maximum punishments that you face?
I don't accept those charges. I got a treaty right here that says I wasn't doing anything wrong.
That's for later. All right, Mr. McLeod, you apparently want to do this the hard way again. I'm just asking you if you comprehend the maximum penalty that they're charging.
I comprehend.
Okay. So
So do you understand that you have the right to an attorney, either hired of your own choosing or provided at public expense? Do you understand that right?
I got you.
Okay. Do you wish to have an attorney represent you, or do you wish to represent yourself?
I'm presenting myself. I'm here by special visitation as opposed to general appearance or lack of subject matter jurisdiction because of 1836 Treaty of Washington, which was further codified in 2017 consent decree, states that my vote does not need to be registered, which makes this unlawful investigation fruit of the poisonous tree.
Okay, so you wish to represent yourself in this?
I'm presenting myself.
Okay. And has anybody promised you anything or threatened you in any way to get you to waive your right to an attorney, or are you doing that of your own free choice?
It's not my free choice, it's under duress.
Oh, you mean that you're not choosing to be here because of the charges? I just mean, so nobody's like making you give up your right to an attorney. Well, I said you got the right to an attorney. You don't want to have an attorney. Is that your choice, or is somebody like pressuring you to not have a lawyer?
What's pressuring you to be here?
That's not what I asked.
Okay.
Is anybody pressuring you to give up your right to have a lawyer?
No.
Okay. See, I'm not asking you trick questions. I promise you, Mr. Mayor. These are not trick questions. All right. So I'm also required to make sure that you are doing this with open eyes, meaning that you understand the risks of self-representation. So as you found out last time, this court has procedures that this court will follow. And when people refuse to follow them, there will be consequences for them. If you're representing yourself, you're going to be held to those same procedures just like a lawyer would. Do you understand that? Do you comprehend that?
I comprehend that this court does what it wants and violated the process when it arrested me. So we lost subject matter jurisdiction. This whole thing is a shame.
That's not what I asked you.
Okay.
Do you comprehend that I'm going to hold you to the same standards of procedures that I would to an attorney?
I don't think that's how it should be done. I think there's case law that says that when people present themselves, they have different standards.
Well, they don't. I mean, I try to work with them as I am with you. I can promise you I don't have these types of conversations with lawyers at the arraignment because they know what they're doing. So I'm trying to give you a little bit more leeway. But you have to follow the procedures as they are dictated by the Supreme Court and the court rules, and as I say them to be. Not what you think they ought to be, but what I say they are. Do you understand that?
I don't understand. I comprehend it.
Okay. All right. Now, because of that, attorneys have had to, be licensed to understand those rules and have me from a law school where they've spent 3 years studying those rules. And so there may be things that they're aware of that you may not be. So when somebody represents themselves, there may be a defense to the charge where a lawyer might recognize that defense and present it, and somebody representing themselves might miss that defense. So when you represent yourself, you take the risk of that happening. Do you comprehend that? All right, so let me give you an example of that. About 2 years ago, I had somebody in my court in my other county, similar to your beliefs about the law. And this defendant was raising similar claims as you're seeking to raise here. And they didn't prevail because courts don't agree with those claims. And the person became so disruptive, I withdrew their permission to represent themselves. And I appointed an attorney for that person against their will. The attorney recognized that there was a defense to the charge, filed a motion, and I dismissed the case on the attorney's motion. The person representing themselves would have never recognized or did not recognize that defense. So do you understand, when you represent yourself and give up the right to be represented by a trained attorney, you're taking a risk that there may be defenses that you might miss?
I comprehend what you're saying,
Okay.
so I think you just move forward from the attorney.
All right. So then the final thing that I have to decide is whether your self-representation will disrupt, unduly inconvenience, or burden the court and the administration of the court's business. If I'm judging it just on last time's appearance, I would say, well, yeah, you're going to be disruptive, so I'm not going to let you represent yourself. Today, you've been tempted to go down that road, it seems to me, but you've trained yourself. So I'll at this point find that you representing yourself is not going to unduly disrupt, inconvenience, or burden the court's business. But you should understand, Mr. McDowell, that changes when you decide that you're going to run this court, which you do not. Then I will withdraw your authority to represent yourself, and I'll appoint an attorney to speak for you, and you won't be allowed to speak. But as long as you're going to, follow the proper procedures, at this point, I'll let you represent yourself. All right. So I will find that Mr. McLeod is unequivocally waiving his right to counsel. He's made that right knowingly, intelligently, and voluntarily, and he's aware of the disadvantages of self-representation. And at this point, I'm finding that his self-representation will not be disrupted to the court's business. All right. Here. Now, Mr. McLeod, I have to arraign you on the charge itself. Have you been given a copy of the document called Information Felony, the charging document that contains the charges against you? Okay. You would have the right to have me read that document in full on the record. Do you wish me to do that, or do you want to waive the reading of the information?
I guess it's for procedure.
Okay. So count one charges you with resisting, obstructing conservation officers, and it alleges that you did knowingly or willfully obstruct, resist, oppose, assault, beat, or wound C.O. Layston Feltz, an officer appointed by the director of the Department of Natural Resources when said person was making an arrest or search contrary to Michigan law. That's normally a high court misdemeanor punishable by 2 years and or $1,000 fine. There is a habitual offender second notice indicating that the court should take notice that you were previously convicted of a felony or an attempt to commit a felony in that on or about February 12th, 1996. You were convicted of the offense of larceny from a motor vehicle, violation of Michigan law, in the 53rd Circuit Court for Sheboygan County. Therefore, that increases the maximum penalty to 1.5 times, meaning that resisting obstructing charge is punishable by a maximum of 3 years and or $1,000. Count two, marine safety operating while intoxicated, alleges that you did operate a motorboat on the waters of the state while you were under the influence of alcoholic liquor contrary to Michigan law. That's a misdemeanor punishable by 93 days and or a $100 to $500 fine and or 45 days community service. Court to suspend privilege to operate vessel 1 year to indefinite, and the court can assess the cost of prosecution or emergency response.
But he was traveling.
Mr. McLeod, how do you wish to plead to those charges? You can either plead guilty, not guilty, or you can stand.
I don't plan on pleading because I have a decree right here that says I wasn't violating any laws. Stop it and lawful, which makes everything after improvement of the street. So well, that's for evidence. Copy of my travel card, a copy of the excerpt from the 2017 consent decree.
Well, that would be like a motion to dismiss later on, which you could file. In fact, you had filed a couple motions to be heard today, and you withdrew them. If you file motions and want them heard, I will hear them. I'll hear your arguments, and I'll rule on them on the merits and the law and the facts. But you can't skip the entering of a plea and go right to a motion. So I first have to enter a plea, either guilty, not guilty, or you can stand mute and refuse to enter a plea. Am I understanding that you are refusing to enter a plea? Which is fine. That's not a violation of court procedure. It's one of your options. You have 3 options right now: to enter a plea of guilty to the charges, to enter a plea of not guilty to the charges, or to decline to enter a plea to the charges. Which of those three options?
I decline any plea.
Okay, that's fine. That's your right to do so. So Mr. McLeod is standing mute as to the charges. The court will enter a not guilty plea on his behalf.
Object to that, Your Honor.
Well, I'm sure you don't want me to enter a guilty plea, so I have to enter one or the other.
Not guilty plea on behalf of the practicing law for the bench. So are you finding a judicial determination that I'm not guilty?
I do not have to subject myself to your cross-examination, Mr. McLeod. That's not how this works. All right, so I'm going to enter a plea of not guilty on your behalf. Mr. Juliet, are the people requesting a referral to the forensic center?
No, Your Honor.
I don't see any indication that Mr. McLeod is incompetent to stand trial, so I won't make such a referral on the court's own initiative. All right, so Mr. McLeod, the other thing I have to do today is kind of pick a day for us to come back, hear any motions that you may file and schedule, or the prosecutor may file and schedule, or to see if there's a resolution of the case, or to schedule a trial. And we call that a docket call because we're calling the case to the docket. So I've got to pick a docket call date. We usually do that about a month out. So I could have you come back Tuesday, February 6th at 9 a.m. Juliet, what would be the estimated length of trial if the case went to trial?
1 day.
All right, Mr. Juliet, anything further from the people?
I received an email yesterday from Mr. McLeod. It appears to be a dispositive motion. I would say suppress the evidence. I know he filed a motion based on summary disposition a while back that was withdrawn. I would just request that if he wants to move forward with that motion to suppress, just give us a copy of the written motion. Perhaps the court can hear it on the 6th. I would just ask 7 days to respond to it.
All right. So, Mr. McLeod, I've done everything I need to do today in terms of determining whether you can represent yourself, advising you the charges, entering a plea, and scheduling our next court date. You can feel free to file any motions or objections that you want to have heard to be heard on that date. I can't rule on things orally on that regard. It sounded like today you wanted to tell me some things about a treaty and things like that. You might be right. I don't know. But I'd have to review your written materials. I'd have to review your argument. I'd have to hear from both sides and then make a decision on that. We can do that on the 6th if you file the motion and notice it up to be heard that day. Is there anything further for purposes of arraignment today?
I'd like to have the motions heard earlier than that. And I'd like to be relieved of my bond restrictions, which are quite invasive, honestly.
Well, you filed a motion to review those and then you withdrew your motion.
Because I want to do it separately.
I mean, well, I guess I could make one exception to that the court rule does allow bonds to be reviewed at any time. So I do allow oral motions to review bond. So if you want to talk about the bond conditions right now, I'll certainly do that.
I think they're very restrictive. I think they're a violation of due process. I think that they're unnecessary to prove that I'm a show up or that I'm not dangerous to the public.
And what those conditions are, because I didn't set them. Those are set by the district court. So let me review here. Which conditions is it that you are thinking are unduly restricted?
They're having me call every morning to take a drug test. So,
Is that the only condition you're seeking to have removed?
It's really the only one that, well, not being able to leave the state is kind of silly too. I travel for work.
All right, Mr. Juliet, Mr. McLeod is objecting to the bond conditions of calling the bond line for testing every day and not leaving the state of Michigan. Any response?
If he works out of state, I have no objection to that. We're striking that from the bond condition. As far as the bond line, I mean, this is an alcohol related offense. It has been a while. I mean, there's been no bond violations, so I don't have any objection to the board striking it.
Okay, now the initial conditions downstairs did say except travel for work purposes. Or, I mean, looking at this charge, I've got a misdemeanor charge. I've got a fairly low severity felony charge. So, I mean, if Mr. McLeod, if you didn't show up for court, that would be a problem. But if you wanted to, you know, go to another state for work or frankly for any other reason, I'm not sure why I would care about that. I don't think this is the kind of case where you would pose a flight risk. So I am going to amend the bond conditions to remove the bond line requirement. And remove the restriction on out-of-state travel. If this were a drunk driving charge with a motor vehicle, I don't think I'd remove that because I think I'd still want to have you testing, but I'm really not too worried. You're going to be operating a motorboat right now anyway. So I'll grant that request with Mr. McLeod and remove those two bond conditions. The court will enter an order so that you don't have to present one to us, effectuating those changes. Anything further for today, Mr. McLeod? Okay, we'll see you on the 6th. If you do want your motions heard on an earlier date, you can contact the assignment clerk and see if there's a date we can get you in soon. All right, have a good day.
Well, he's not as bad as he could have been. I think he was in the first hearing, which I didn't get. But you know what? This judge keeps his videos up, so I might be able to go back and find that if I just try. Um, but I don't know how it's gonna be at the next one. He was traveling. He was traveling drunk. Can't do that. It's on a boat though. I mean, do you ever go on a boat and not be drunk? Do people actually do that? I don't know anybody who does that. Like the first thing that goes in the boat is the cooler. And if anybody got in an accident on a boat, I'm sorry. I'm joking. I'm sorry if I offended you about that. I would be kind of mad if I got in a horrible accident because of a drunk boater. Well, thank you all for coming out. I really, really appreciate it. I hope you had a good time. I have plenty for tomorrow. And I have off work tomorrow too. So I might do a real long stream tomorrow. I don't know. We'll see. All right, guys. Have a good day. See you tomorrow. Bye.